I have a set of questions that was suggested by the Peter and Patricia Gruber Foundation, and after that, we will enlarge the discussion to incorporate your questions. So my first set of questions are for Justice Argibay. And the question comes in three parts with an introduction. The introduction is that in the 1980s and 1990s, members of the military who allegedly committed gross violations of human rights were accorded what Mónica just referred to as impunity from prosecution and other liability. That situation has changed, and now there are three questions. First, what actions did the different organs of government, the president, the legislature, and the judiciary, take to withdraw that immunity from the military officers? And second, have any prosecutions in fact been instituted against the alleged human rights violators? And finally, did international human rights figure in the withdrawal of impunity from those human rights violators? So if you can start with what role did international human rights have in promoting the change that occurred, in promoting the withdrawal of the immunity?
Mm-hmm. Okay. Yeah, thank you, Justice Ginsburg. I'll try to be short, but try to be clear. After the democracy sets in 1983, at the end of 1983, there was a resolution by the government, the democratic government of President Alfonsín, to try all the junta members. That means that the highest military in the country, who were the minds behind all the horrors that had happened in my country. But then the military at that time were very, very powerful still yet, and they started new movements against the government. So the Congress, the Parliament, passed two laws. One that was to say, well, we are going to put a full stop, and we are not going to admit new trials, new prosecutions. We'll stop with the ones we have. And then afterwards, as the military thought that this was not enough, they wanted more, they had to sanction a law in Congress too, in Parliament, to say that, well, under a certain level in the military, they were all under orders. So that was the due obedience law, and so they were just accepted from prosecution because there was the responsible persons were the chiefs, the officers, the higher ranking officers. So this went on until, we have another thing. We have the pardons by decree of some of the military who had been already tried and sentenced, and when sentenced to life, they were pardoned by President Menem by decree. It was a faculty, something that the Constitution said the president has the possibility to pardon some persons. And, that was a situation until 2003. 2003, with the new government, the new president, the idea of repealing the laws, the due obedience and full stop laws, was taken by the parliament, and they say, okay, we just were forced to pass this law. We were just under duress, and this is invalid. We are going to nullify these laws. But then it's all the rule of law says that you can derogate a law, but you can nullify it backwards, let's say. So there was a problem, and they started to be some trials, and they went to the Supreme Court with some of the trials, and there was a decision in June 2005 that the court said that those two laws were unconstitutional because the Constitution has incorporated all the treaties and conventions on human rights, and one of the conventions says that you can't apply the statute of limitations, or you can't pardon, or you can't anything to warrant impunity to crimes against humanity. And so, if the tribunals, the courts, were saying that those were crimes against humanity, then we should go forward with the trials. And that's what is happening. This moment, just today or yesterday's night, I had the news that one of the person who was on trial because he was just helping to torture prisoners in some of the clandestine detention centers. There was a priest of the Catholic Church was just sentenced to life, and I'm very happy that had happened. Yeah, and I think this is the way to do it, because we are doing the trials with the proper judges, the civil judges, not military judges, the civil judges nominated, appointed, as the rule of law said they should be appointed. They are not a person who was selected just to do this. No, they're common, simple, normal judges that are doing their work, and they are doing a very hard work, and they're working very, very well and very good. And so this is not the first sentence of one of the military or people related to the military in my country. There's already been 2 or 3 after the Supreme Court just repealed these 2 laws telling that it was unconstitutional. And there are a lot of them coming. It would take a long time because there are a lot of people there. And the people in general, all the victims, all the families of the victims are not eager to let them go by. So I think we have trials for a lot of time, but the thing is that all the organizations that have to do with human rights around the world, and I think, for instance, one of the visit of Amnesty or Human Rights Watch or whatever, or the Commission of Human Rights, the American Commission of Human Rights, kept the country in touch with the world and kept all the person who could oppose the dictatorship or to try to bring back the rule of law to our country, just supported by all these organizations. Then it's much more, I won't say easy, but still you feel like you're not alone, and you can do a lot more if you have people supporting you. And that's the great thing about all these organizations. Thank you.
You've answered the last question that it was through it. You have answered it because you explained that it was through the medium of your human rights treaties that you were able to undo the prior law.
Yeah.
But I had just one follow-up question. The approach is obviously quite different from the South African experience, where it was decided to set up a Truth and Reconciliation Commission. The people came forward and confessed to their crimes. They would not be punished. Has there been anything comparable in Argentina?
while those periods that we weren't able to have the trials because those laws were enforced in Argentina, then there were some judges or some courts in the provinces that were making what they called the truth trials. It was not the truth commission, it was the truth trials. It was like a moot trial, but that people could come and say, but never the perpetrators had come before one of these commissions or trials. Never. It's always the victims, the witnesses, the families, the survivors, but never the perpetrator. Well, if it's a trial, a formal trial, you have to come. You're a defendant. I'm sorry, you have to come, and you have to be in prison. That's it.
Can you give us an idea of the length of the sentences?
The length? Well, no, it depends. There would be some of them that were related to some part of the army or the navy that are very, very big. That would be very difficult because you have a lot of defendants that would take a lot of time. And then on the other hand, there's a lot of problems 30 years after or 28 or 27 to take the evidence, to have the evidence, to find the witnesses or the victims. Some of them are dead, others have moved, the others are refugees in other countries. You can take them back to go on the witness stand. It's difficult. I don't know how long we will take, but we'll do it. I hope.
Thanks so much, Justice Argibay. And for Judge Cerda, I have been asked to pose these questions. First, if you can describe to us in short the prosecutions that have been instituted in Chile against General Pinochet and members of his family. That's the first question. And the second is, would those prosecutions have occurred in your country had there not been the assertions of universal jurisdiction, first by the magistrate in Spain and then in the UK?
Si no lo hubiera hecho Garzón, si se hubiera hecho en el país.
Sí, exacto, que si Garzón no hubiera invocado los principios
Perfecto.
de jurisdicción universal en caso de derechos humanos.
Unfortunately, I cannot to respond directly in English, so I will do so in Spanish, and Patricia Cepeda will translate that. Causas seguidas respecto de Pinochet y su familia. Sí, a partir de los años en los cuales todavía gobernaba Pinochet, estamos hablando de el último lustro de los años 80, hubo acciones dirigidas en su contra como una manera de saber el destino de detenidos desaparecidos principalmente y de sancionar a quienes habrían torturado según se denunciaba.
About the cases against the General Pinochet, starting in the 80s when he was still in power, there were some cases brought against him, but mainly to see what had happened to the detained or disappeared.
Pero el conjunto de antecedentes que toma mayormente fuerza desde el punto de vista procesal respecto de Augusto Pinochet Ugarte, que en paz descanse, digamos, tiene lugar con motivo de su detención en Londres a raíz de una orden de aprehensión que, como ustedes conocen, se había emitido en España por la fiscalía de la que formaba parte el juez Baltasar Garzón.
But from a procedural point of view, things really started to happen against General Pinochet, may he rest in peace, with the arrest warrant by Judge Garzón made from his Spanish base, which then led to the whole chain of events.
¿Por qué el conjunto de antecedentes toma fuerza a partir de entonces? Porque con el regreso de Pinochet al país, todos los sectores, incluso aquellos sectores civiles que en su momento lo habían apoyado, comparten la idea que debe ser en Chile donde se lo someta al due process of law.
Why did this fact of his arrest ordered by Judge Garzón in London led to this whole chain of events? Because it gives his return to Chile is what leads all various sectors of society, even those that had supported him, to realize and to become conscious that he must be tried in Chile, where he would be subjected to the due process of law and not abroad.
Se inicia una serie de investigaciones por el juez Juan Guzmán Tapia, que también ustedes han escuchado, y que son en número de centenares y que tienen relación con las denominadas violaciones a los derechos humanos.
Hundreds of cases were investigated by Judge Guzmán Tapia, whom you have also heard from, and that there are hundreds of them. They mostly have to do with the violations of human rights that occurred during the dictatorship.
Se hace muy difícil la eficacia procesal cuando un juez tiene tanto que investigar.
It's very hard to be efficient in hearing all these cases because one judge has to investigate all of them.
Entonces, el año 2002 se toma la decisión de dividir estas investigaciones y distribuirlas en un número de jueces elegidos por la excelentísima Corte Suprema de Chile.
In 2002, the decision was made to take these hundreds of cases and divide them among a select group of judges chosen by the Supreme Court of Chile to hear them.
La mayoría de estas investigaciones, de estos cases, están abiertas porque se someten al antiguo procedimiento penal vigente en Chile, un sistema inquisitivo, y han ido concluyendo muchas de ellas en condenas a quienes tuvieron a su cargo, según se ha comprobado en esas causas, tales violaciones a los derechos humanos.
Most of these cases are still open, but some of them have already been finished and they have resulted in sentences to people proven to have violated human rights during the period.
No hay limitaciones de ningún orden en estos procesos, de tal manera que se puede decir que los jueces que los tienen a su cargo son totalmente libres y es posible en plenitud cumplir las exigencias del due process of law.
There aren't any limitations in how long these cases can take for the judges to be able to fulfill due process in hearing all of them.
Termino respondiendo la pregunta de Justice Ginsburg en el sentido que paralelamente y a raíz de descubrimientos efectuados por el Senado de este país, de los Estados Unidos de Norteamérica, se inició una investigación en 2004 respecto de posibles desfalcos, mal uso de dineros públicos, lo que llamamos malversación de caudales públicos, tal vez, respecto de Augusto Pinochet Ugarte y sus cercanos, entre los cuales parientes y colaboradores.
In 2002, because of a U.S. Senate investigation, it was possible for us to bring cases against the Pinochet family, close circle of collaborators and friends on the possible misuse of public funds.
esa investigación está vigente, activa, abierta.
That case is open.
Again, we see the effect of opinion outside the country in promoting judges inside and giving them courage to proceed. And you mentioned specifically Garzón in Spain, the UK, and most recently the United States. So I thank you.
You are welcome.
And now I'd like to ask Mónica Feria this question. It has been reported that in reaction to the ruling that you won for your clients from the Inter-American Human Rights Court in the prison massacre case, there have been some political actors in Peru advocating that the court's ruling should be defied, should not be observed, and even that Peru should withdraw from the Inter-American Convention on Human Rights. Can you tell us what those actions have been and the prospects for their success?
Thank you for the question, Justice Ginsburg. Yes, the Castro prison case was adjudicated by the Inter-American Court, who handed judgment in November 2006, 25th. The judgment made a very, very big impact in Peru. It was in the news for a month, perhaps. And the feeling in Peru was uneasy because for almost over 13 years, the version of the facts in connection to the prison massacre was that there was not a massacre. That what took place there was an attempt to transfer women to another prison, and that there was a riot. And that was just perhaps a little bit of an excess of use of force. That certainly was not a crime, and nobody was prosecuted for that. But that in any event, it was not a massacre. And it did not, the society did not acknowledge either the treatment that survivors were given, in particular, all the different practices of torture. It was never really acknowledged also the infliction of violence against women, including to women that were pregnant during the time, the use of a number of illegal weapons and practices on people that were incarcerated and had no means of defense in their condition. So it did broke a lot of, perhaps it was difficult for Peru to accept that an Inter-American Court of Human Rights had asserted the facts differently from what had been the official version. I believe that there is still a process to digest the truth. Truth is something that can be denied, but eventually I firmly believe that societies, in order to move forward, have to accept facts. What Peru did immediately as a consequence of all these general upheaval surrounding the decision in Peru was to say or suggest that perhaps the Inter-American Court had gone too far. In fact, Peru participated throughout the 10 years of litigation actively in the proceedings. It had representation throughout the commission stage and throughout the court stage of the case. It participated in the hearing, and during the hearing took place in El Salvador, and at that hearing, the administration of Toledo acknowledged that it has taken place a massacre in that prison. So Peru itself acknowledged partially what had taken place towards the end of the litigation. We managed to bring experts and prove the facts in a way that in the judgment this could be clearly reflected and the law could be also stated in a very clear manner for the future and for other jurisdictions. So Peru has now, with the change of government, with Alan Garcia, who came to power, the administration changed maybe its views about the standing that the state had taken with this particular case. But that is not an issue of international law. States are accountable as states, not as governments. Its latest position has been that they wanted an interpretation of the judgment. The court made it clear that the court cannot change a judgment. There has to be specific legal issues that may have obscurity. Those were the only basis for asking an interpretation of a judgment. In my opinion, that basis has not been satisfied in this case. The court is going to decide on this issue towards the end of this year. But something to point out is that Peru has not challenged the facts. Maybe the media has reported so, but in the actual brief that Peru presented, Peru has asserted that it's bound to comply with the judgment, that is bound to respect the inter-American system. It has clearly stated that it believes in the work of the court. So perhaps the media has distorted as well what Peru as a state stands right now in the actual proceedings. So I hope that towards the end of the year we will have a decision by the court and the position will be clarified. The court has already said that interpretation of the judgment does not stop the legal effects of the judgment. One of the issues was the prosecution of Fujimori, and the court was clear to request from Peru that Peru does all the judicial and the diplomatic, takes all the measures in both aspects to ensure that all the individuals who were participating with different degrees of responsibility in these atrocities are prosecuted. And we had a recent exchange of communications with the court and with Peru just days before the extradition. I did file a paper where I suggested to the court I was deeply concerned about the lack of action on the part of Peru to present the Castro case as one of the most serious cases currently pending against Fujimori in Peru, as one of the extradition cases in Chile. And within 3 days, Peru issued a formal legal resolution signed by President Alan Garcia, who approved to send this new cuadernillo de extradición, this new file, to Chile, so that Peru can comply with the judgment of the court. So that's what I can comment so far. Thank you.
Has there been any compensation, in fact, paid to the victims up to this time?
No, Peru has a term to comply with those aspects of the decision. The court established that the period is 1 year and 8 months. This is a very, very big case. We're talking about considerable amount of individuals. So there are many aspects that has to be implemented before being able to comply with the compensation aspects. And so it's still early times to make assertions as to what is going to happen in that respect, but we are going towards a year already since the decision was issued. So Peru still has another 8 months to work on the implementation of that measure.
Thank you.